So when divorcing my husband, do I get to keep the things that I own before the marriage? The answer is yes, if you can prove that you had the items before you got married. Hi, I'm board certified divorce lawyer Christopher Bruce of the Bruce Law Firm. Let me tell you how this all works. In Florida, what the law says is that in a divorce, all marital assets are divided in a way that is presumed to be equal, but the court can divide things in an unequal manner. And that equitable distribution law, as it's called, which is 61.075 of the Florida statutes. And what Florida law also says is that if you show that you had something before you got married, then it is your premarital asset and falls into the category of what is not divided with your spouse in the divorce. But you can't just go and say, hey, I own that before I got divorced. You have to prove it. And this can be tricky when it comes to things that you can pick up and move around or money. You really have to have a way to show that you had a certain thing before you got married. With real estate, this is pretty easy. There's a deed to the house or there's a title to a car. Those things have dates on them. But for the stuff that does not have dates, it can be a little bit trickier to show when you acquired the item. Then there's the bank accounts and investment accounts. You need to have statements showing that the account existed when you got married. And to take it a step further, unfortunately, you have to show that during the entirety of the marriage, you did not commingle, meaning mix that non-marital premarital account with funds that would be considered marital in nature. And that really means you're going to need a lot of bank statements. Without having all of the bank statements during the marriage, it may be very difficult to prove that what's in that account that you had at the time of marriage is only the money that you had at the time you got married. And with the way that Florida's laws are set up on this, and by the way, a lot of other states are the same, you have the burden of proof to show that something is premarital and falls into the category of items that you don't divide with your husband. So to really sum it all up, yes, if you owned something before the marriage and you can prove that you owned it before the marriage and that you've always kept it separate from what are the marital assets in your case, then you don't divide that asset, that premarital asset, with your husband. Any questions about this? Any thoughts? Put them in the comments below. Like and subscribe for more. Check out all the valuable information in the description, including links to our free resources, including our Florida divorce law guide, a free guide that explains all the different aspects of how the laws work in a Florida divorce. If you're getting divorced in the Southeast Florida area, that's Vero Beach, south to Miami, please consider the Bruce Law Firm. And I hope this has been helpful to you. Catch you next time.